This is Rob Eggmann, and I'm with the Carmody MacDonald law firm in St. Louis. And I'm going to talk just a little bit about representing the borrower or the defendant in a receivership action. And there are really two types of borrowers or defendants we have here. Those who have defenses and they're going to fight the receivership, and those that, generally speaking, do not. Topic one could take really about an hour. So I think right now I'm going to concentrate really on topic two, because that's what we see most often in the receivership actions. And when I say these folks don't have defenses, what we're really dealing with here are bank initiated or lender initiated receiverships. Typically, you have loan documents in place that are in default, and most frequently you have one, two, or maybe even more forbearance agreements in place prior to the receivership. Typically in those forbearance agreements, there will be waivers of defenses, waivers of counterclaims, and oftentimes they'll contain provisions which actually even will consent to the initiation of a receivership action. We see those more and more frequently each day. In addition, I'm assuming that in most cases we have a Missouri borrower or borrower at least in the same state that the receivership is being initiated. So we do not have any issues regarding defenses as to the location or jurisdiction of the receivership action. So what do you do in cases like that when you're representing the borrower with what appears to be very little leverage and very few defenses? My goal always is to really two things. Try to get the borrower something that maybe they're not going to get but for your hard work in the case. And secondarily, making sure that the lender and their counsel are going to put a fair receivership order in place. While the receivership statute is very extensive, it does not really specifically state what should and should not be in the order, nor should it for that matter, because every case is different. But what I'm looking for in the orders and looking to remove are items that take too much corporate authority away from the borrower. Clearly, the receiver is going to run the show, and we get that. That's the point. But like, for example, one of my big issues is do not let the order contain a provision that prevents the borrower from filing any type of bankruptcy proceeding. I think that there's an issue as to whether that's enforceable anyway, but I think that's very important to try to have taken out up front. Second, what are the receiver's duties going to be towards the borrower or defendant? And by that, I mean, oftentimes the receiver will want to take out of the equation important things such as tax returns and things of that nature. And again, I think this is very important that everyone knows who's going to do what. So make sure your order makes it very clear who's going to file tax returns, and most importantly, how the accountant is going to be paid to file those tax returns. Likewise, that goes for not just income tax returns, but also 941s and things of that nature. Finally, another important aspect is that you want to find some way for you as the lawyer to get paid, because once you're in the case, you're in, and you're going to be responsible for doing things such as filing the schedules, reading pleadings, appearing in court. And even if the order is clear, there still may be instances where the borrowers may wish to object to certain things taking place in the receivership. And what immediately comes to mind for me would be sale of assets, either outside the ordinary course of business or as a whole. So I think the long and short of it is, I think the most important job as counsel for the borrower here is to make sure you negotiate a fair, reasonable order that follows the statute, but tries not to go too far beyond the statute in order to allow the borrower to actually receive a benefit from the receivership potentially as well.